Hi, my name is Zara. I'm currently from Northern Virginia. I was mentored by Danielle, and I am so grateful to her. She was so helpful throughout this whole process, and I just wanted to take this moment to thank her. So, today I'm going to be talking about discrimination within the criminal justice system, particularly in respect to plea bargaining. So, the title of my paper is The Impact of Plea Bargaining on Existing Disparities in the American Legal System. Okay, to start, I kind of want to give a brief overview about plea bargaining and what it entails. Basically, plea bargaining is a procedure that allows prosecutors to negotiate sentences with the defendant. Now, this essentially will lead to an admittance of guilt and in exchange for a reduced sentence. While this process does help streamline the criminal justice system, as there tends to be an overwhelming amount of cases, it raises major ethical concerns. So, my thesis is my paper explores how how plea bargains contributes to and sustains discrimination within the criminal justice system, particularly the overrepresentation of minorities in prisons. It also delves into the relationship between legal representation and outcomes of plea bargains. To start, I want to give a brief overview about the history. The history is kind of obscure because it was considered pretty untraditional and unethical before it became normalized in the 1960s. Many believed that it was not fair that people should be able to negotiate justice, and justice should be something that is served with a judge and a jury. In more recent years, however, plea bargaining has become the norm, with 98% of federal cases and 95% of state offenses being resolved through plea deals. In fact, states such as Texas and New York only see trial rates less, about 3% or less, every single year. So I keep talking about these ethical concerns, but what exactly are these ethical concerns with plea bargaining? One of the primary ethical concerns with plea bargaining is that when someone enters a plea deal, they are giving up their constitutional right to a trial. This can be seen as a problem, as people believe that when you give up this right, you're giving up the right for justice to be served for yourself. Another huge issue is the fact that prosecutors are given too much discretion over the case. Now, why is this a problem? It's a problem when prosecutors have too much discretion in this case because they tend to act in their favor. Plea deals really simplify the whole trial process, as it helps the case avoid going to trial at all. So it saves the time and exhaustion and money that it would take to actually host a trial. So with all of these tempting sort of benefits that come to prosecutors, it leads them to use sort of coercive methods in order to make people accept plea bargains. So some of these coercive methods, I'm sorry, some of these coercive methods can include the threat of minimum sentencing and the threat of a long pretrial detention period. So minimum sentencing is the minimum sentence that one can get for a crime. And it completely does not factor at all the person, the situation, the circumstance, or any other factors, which is why the minimum sentence actually tends to be a lot more than what the person could have actually got if they went to trial. So this threat of getting a minimum, this threat of having a minimum sentence can be huge. Another threat is the threat of pretrial detention. Pretrial detention means that you are being held while you are still considered legally innocent. And the length of which you are detained can be very obscure considering it has to do with when the trial date is and so much more. When in pretrial detention, you have to deal with things such as not being able to talk to your lawyer as frequently, not being able to see families often, and so many more, which can also affect the mental health of the person who is being held. So, with these threats, it just amplifies the coercive nature of plea bargaining and plea deals in the criminal justice system. Now, I want to get into some racial disparities. Primarily, the issue is that minorities are being overrepresented in the criminal justice system. And we often think about it as minority communities are being over-policed or they're being, like I said, overly represented, as Black males are incarcerated 5 times the rate as white males today in the US. However, a factor that often goes overlooked is the sentencing disparity. So the sentencing disparity says that typically when offered a plea deal, minority communities get the 90 sorry, in New York, 91% of minority communities got the mandatory minimum sentence or the harshest sentence in their plea deal compared to about just 9% of their white counterparts. This is a huge gap between the sentencing, and so that can raise some serious problems. And additionally, for white males, it's 25% more likely that harsher charges against them will be dropped. So this systemic bias in plea bargaining kind of amplifies the existing inequalities, which is really harmful in the serving of justice in our legal system. Next, I want to talk about legal representation and how it kind of affects plea bargainings and the offering of plea deals. So when I was first looking into my project, I really wanted to answer the question if better money bought better outcomes. And it is partially true. However, there is very few data and statistics on this topic because that would mean that the criminal justice system would have to admit that there is some sort of racial discrimination or socioeconomic issues. Um, what I found is that defendants who were represented by a public defender, meaning the defender was provided by the state when you can't afford your own defender, they were 71% more likely to be arrested compared to 50% of those people who were represented by private counsel. However, I would like to note that this statistic is quite old. This statistic was released around 3 decades ago, and so it is very likely that things have changed since then, but that is the primary statistic I found on this. And plea outcomes specifically, I wanted to know whether or not counseling had anything to do with if people were offered plea bargains more often if they were represented by a public defender. And that isn't really true, but it especially puts into consideration that it's not true primarily because, like I said before, 98% of offenses are resolved in this way. So it makes sense that most private and public counsel would rather just go with the plea deal rather than go to trial. Okay. Finally, I want to talk about my potential reforms. So there are 3 primary issues that I brought up, which is the threat of pretrial detention, the threat of a mandatory minimum sentence, and the threat of kind of an overwhelming amount of cases that overrun the criminal justice system. Today, we face a huge shortage of public defenders, with states saying that they barely have enough public defenders to just even fuel their countywide cases. This leads public defenders to have even more work on their hands, leading them to only allocate about 1 to 2 hours per case that's on their desk, With 1 to 2 hours per client, you're barely able to get thorough investigation, thorough research done, have a conversation with your clients, and so much more. So one of my solutions is that we need to incentivize going into criminal defense law. Now, currently, out of all the other law niches, criminal defense law is kind of seen as the most unappealing one, considering that they have to do twice the work for half the pay. So I want to incentivize people going into criminal defense law by raising the pay. If we are able to raise the pay, then it will be more likely that more incoming graduates will go into criminal defense law and choose this as their niche, which will spread the work out more evenly across all criminal defense workers, meaning they could spend more time on each client, on each case, and then wouldn't have to resort to plea bargaining as an easy way out. Another one of my solutions is that we need to remove the threat of pretrial detention. Pretrial detention is used as a coercive tactic, as they are threatened with, if you don't accept the deal, then who knows when your trial is going to happen and who knows what's going to happen to you. You can be in pretrial detention for weeks or you could be there for months. So if we remove the threat of pretrial detention completely, this will completely remove that extra added layer of coercion. Now, there are some issues with removing the threat of pretrial detention, such as flight cases. Pretrial detention was initially used as a method to make sure that people stay put and they don't try to flee or run away while their trial is in process. So there is that to think about. And so I think that we wouldn't have to remove pretrial detention entirely, but it shouldn't be as much of a factor as it is currently, and it shouldn't be used as such a threat. And finally, I want to talk about mandatory minimums. Mandatory minimums are a huge problem because mandatory minimums completely, oh, yes? Oh, sorry.
Just to let you know
Mandatory,
you're close on time.
yeah, sorry, okay. Mandatory minimums completely remove judge discretion and prosecutorial discretion. So no one really gets a say. The minimum that you get is the sentence that you have. So this can be a huge problem in the criminal justice system as there's so many compounding factors that have to do with how much time a person is given. So I believe with removing the threat of pretrial detention, removing the threat of mandatory minimums, and increasing and incentivizing criminal defense law, we can potentially see a decline in the use of plea bargaining. Okay. In conclusion, the overuse of plea bargaining in the American legal system has dire consequences as people aren't being represented the way that they should be and justice isn't being served. The practice leads people to often give false admissions of guilt, be held for an unknown period of time, and just waive their right to a trial as a whole. But I believe through comprehensive reform and policy, we're able to ameliorate this problem. Thank you.
Wonderful job, Zara. Thank you so much for that topic. It is I used to debate in college, and this was actually, I mean, I don't want to date myself, but this was a problem back then.
Yeah.
And it was
And
great
it's
to hear.
often overlooked. People don't really think about the sentencing period, I feel.
Yeah, and I think you hit the nail on the head. I mean, mandatory minimums and pretrial detention are threats that cause people to plea bargain. They don't want to spend all that time. They'd rather just get it done.
Yeah.
I found it really interesting. Like I would have not guessed 98% and 95% of cases are plea bargained out. I thought that, I mean, I knew it would be high. I had no idea it would be that
Yeah.
high. So, thank you for sharing that. Um, when you were talking about the money in in these decisions, like if people could afford to have an attorney, would that go down? And you're like, well, there's not that much data there, and the 98 and 95% seems to suggest it wouldn't matter, right? It seems that they're
Yeah.
almost always being plea bargained out. But the ones that when you were talking about the racial disparity in sentencing,
Mhm.
did you find any data that said that um, that typically white offenders have better representation because of money and therefore get a better plea bargain? Was there any data around that?
So no, I really I searched a bunch of journals and everything. This is not something that is heavily reported on because like I said, that would kind of mean that they would have to admit that there was some sort of socioeconomic disadvantage. And the reason that I asked this question is because I did factor that in how it is typically disadvantaged, impoverished minority communities that are being over-policed. So I figured that money would be a huge factor in whether or not that, legal representation would have an effect. And the only statistic I found was, like I said, 71% of those represented by um, public defense, 71% of those people were incarcerated compared to 50% of white people. And I also mentioned that 25% of white males are more likely to have harsher charges against them dropped completely, where minority communities are typically getting like the max sentence that there is to get.
Yeah.